Last week, we went over the law of evidence and we understand how it generally works. You recall that the basic structure is relevance, foundation, and relevance, foundation, and exclusions. Some of you may have a different approach to doing evidence questions. That's perfectly fine if you have some other approach that gets all of the elements, as long as it works. Tonight we are going to do problem solving almost exclusively because we got through most of the code last week, certainly the most critical parts of it. And so we will do problems. We will begin with this problem, July 99. If you will take a look at that, I will give you just a few minutes to review the facts of the July 99 question. So if you'll do that in the next 3 or 4 minutes, we will then go through the analysis together. I assume that you have studied the question and done it for homework, but please refresh your notes. I'll give you 3 minutes. We'll start. Okay. We are going to look at this question from July 99. Let's do it together. Mary Smith sued Dr. Jones, alleging that Jones negligently performed surgery on her back, leaving her partly paralyzed. In her case in chief, Mary called the defendant, Dr. Jones, as her witness. So she's calling a hostile witness. That means you can use leading questions. The following questions were asked and answers given. And then you ask at the end, what objections should or could Dr. Jones' attorney have reasonably made to the questions or answer at each of the marked places? And how should the court have ruled? And we have 8 marked places, and you see where those are. So, the first one. Question. Now, you did not test the drill before you used it on Mary Smith's vertebrae, did you? And the question is, what objections would you make? Well, this is in the middle of the trial, obviously, but even so, starting with working with the information we actually have, this question is assuming facts, not in evidence. I'm sure that's obvious to you, and that you should say that. So number one, this says, now you did not test the drill before you used it on Mary's vertebrae, did you? And so that's assuming facts, not in evidence. It is also a leading question. You can identify leading questions often because leading questions are questions where you can answer yes or no, because the question itself contains the answer. So most of the time, if you can answer yes or no, look to see if it might not be a leading question where you really are, the answer is contained in the question. So here the answer is contained. You did not test the drill before you used it in her vertebrae, did you? And so we have a leading question. We have assuming facts, not in evidence. And I answer to both of those. As to the leading questions, this is a hostile witness. Explain that. As to the assuming facts, not in evidence, point out that you assume this is in the middle of the trial and that the facts that are used here in the question have been put in evidence. Number two, that's not part of his answer. That's not part of our procedure. We don't ordinarily do that. Now this is Dr. Jones speaking. And the question, what you're asking is, what you were asked is, what objections might Dr. Jones's lawyer make? So if you're Dr. Jones's lawyer and Dr. Jones says, no, that's not part of our procedure. We don't ordinarily do that. That is, I mean, if you're Dr. Jones's lawyer, I wouldn't prevent Dr. Jones from saying that, because this helps Dr. Jones's case. We don't ordinarily do that. And so I didn't do it, because that's not part of our standard procedure. Rather than I was negligent and failed to do it. So if I were Dr. Jones's lawyer, I would leave that in there. Wouldn't try to get it taken out at all, because I think it's helpful. And that's what I'll explain. Item 3. Well, since Mary's operation, you now test these drills immediately. By the way, I'm sorry, let me go back to number 1. Something I forgot. I knew there was a third one and I forgot. Number 1, where it says, now you did not test the drill before you used it on Mary Smith's vertebrae, did you? I thought that the question was unnecessarily inflammatory. You can ask questions in such a way that such a way that it really is just seeking information. But you can also ask questions in such a way that you really are trying to inflame the jury. In this question, you did not test the drill before you used it on Mary Smith's vertebrae, did you? I think that's unnecessarily inflammatory. You could just ask, did you test the drill before you used it? But painting the picture of the drill going into someone's vertebrae was not necessary to get the information that he wanted. And so so there's a third objection to Part 1. The third objection to Part 1 is it was unnecessarily inflammatory. That means it is substantially more prejudicial than probative, your 403 objection. So the three objections to Part 1 are, number one, that it is assumed facts not in evidence, probably okay, especially in the middle of the trial. Secondly, it's a leading question, hostile witness. Thirdly, the question is put in a way that is unnecessarily inflammatory, and that violates 403, claiming it's substantially more prejudicial than probative, and you would need to explain why putting the question this way was more prejudicial than it needed to be. Then as to the second call, no, that's not our procedure. We don't ordinarily do that. If I'm Dr. Jones's lawyer, I wouldn't object to that. I would leave it. If you are Mary Smith's lawyer, you might ask the court to strike part of that this is, pardon me, that the witness was not asked about what they ordinarily do or any of that, and ask the court to strike the parts which are non-responsive to the question. So you could claim that everything beyond the word no is non-responsive and should be stricken, but that's something Mary Smith's lawyer would claim, not Dr. Jones' lawyer. Third item. Well, since Mary's operation, you now test these drills immediately before using them, don't you? Well, again, leading question, but that's okay. This cross-examination. It's a hostile witness. But this is also has the objection of subsequent remedial measures. That's 407. Subsequent remedial measures, FRE 407. Excuse me. And if they are now testing the drill as a subsequent remedial measure, that's not admissible to show fault. So the objections to Part 3, item 3, are leading question as before, and subsequent remedial measures not admissible under 407. You don't have to cite the code numbers. Then we come to the next answer, yes, but you were not asked to comment on that. Now comes Part 4. Just before you inserted the drill into my client's spine, now there's your 403 objection again. You heard Nurse Clark say, the drill bit looks wobbly, didn't you? So you're asking him, you heard the nurse say, the drill bit looks wobbly, didn't you hear that? He says, no, I didn't, but we're going to object to the question itself. What objections would you make? Did you hear the nurse say that drill bit looks wobbly? Well, if you're offering that to prove the drill bit was wobbly, then obviously it's hearsay, because you're asking this doctor if you heard somebody else say it was wobbly. So if you're offering it to prove that the drill bit was wobbly, it's hearsay and there's no real exception. If you're offering the statement that the nurse supposedly made to Dr. Jones, the drill bit looks wobbly, if you're offering that just for notice to Dr. Jones, that the drill bit looks wobbly, well, the mere fact that Dr. Jones should have heard it would provide notice. Now, is it relevant? And we can't offer evidence that isn't relevant, doesn't tend to prove something in the claim. And here, the saying that the drill bit was wobbly, if that's offered for its truth, of course, that would tend to show medical malpractice. And if the drill bit, if the doctor heard somebody say the drill bit looks wobbly, then the doctor now has notice. And if in fact the drill bit was wobbly and the doctor ignored the notice, telling them it's wobbly, just went on and used it anyway, now you have gross negligence at least, maybe worse. So your objections to this question, didn't you, Dr. Jones, hear the nurse say so-and-so? Well, what you're trying to get into evidence is what the nurse said. And you're asking, doctor, didn't you hear the nurse say that? And so if it's what the nurse said is being offered for its truth, then hearsay. But if it's being offered, and there's no exception, if it's being offered for the fact that it gave doctor notice, then it's relevant on the issue of damages, because you now might get gross negligence or punitive damages. So our objections here are to Part 4. First, we have a 403 objection, substantially more prejudicial than probative. Then we have a hearsay, and we have, but if it was offered just for notice rather than its truth, then it's relevant on the issue of damages. This brings us to the doctor's answer. The doctor says, no, I didn't. Next question. Let me show you what has been marked as plaintiff's exhibit number 10. So he shows in the document. Says, this is a surgical report written by Nurse Clark, isn't it? And the doctor says, yes. So notice now, we are not asked to comment on this, but we have authenticated the report by the nurse. So someone who knows recognizes it and says, yes, that's what it is. It's not just an ordinary piece of paper, it's that report. So the report has been authenticated at this point, but we weren't asked to comment on that. And now at item 5, in her report she wrote, at time of insertion, I said the drill bit looked wobbly. Didn't she? So remember that Dr. Jones is on the stand, and I've got this report, and I'm saying to Dr. Jones, doesn't this report say that at the time of insertion I told Dr. Jones the drill bit looked wobbly? So I'm asking Dr. Jones, isn't it true that this is what the report says? And you're asked to comment on that as item 5. Well, we've got several things. First of all, this is a report, and so we need to authenticate it. And you can establish that it's been authenticated just for the reasons we've just talked about, because someone told the court what this document was, somebody who knew what it was. So it's been authenticated. Secondly, we obviously are still have a hostile witness, and so we can ask leading questions. But then the report says, at the time of the insertion, I said the drill bit looked wobbly. So we're reading to Dr. Jones what this document says. So it's the content of the document that we're really trying to get in. And we're trying to get it in by asking Dr. Jones, didn't you hear this being said? Now, but if we're going to read to Dr. Jones what the report says, we need to first authenticate the report. We did that. And then if we're reading what it says for its truth, we've got a hearsay problem. If we're offering the fact that it's true that the drill bit really was wobbly, then we've got a hearsay issue. And now, can we get past the hearsay? Well, the nurse who said it, let's think about this for a second now. Typically what would happen is you got this operating room, and you've got some doctor doing the operation, and you've got some other people there helping out. So let's say you have a nurse, and you have two nurses, nurse 1, nurse 2. Nurse 1 says to doctor, the drill bit looks wobbly. Now, if this nurse 1 was later asked to testify to what did you say to doctor, this nurse would say, I said to doctor the drill bit look wobbly. She offered for its truth. So I I saw the drill bit, it was wobbly. I even commented on it. I said the drill bit looks wobbly. So if you call the nurse who said it to the stand, this person would tell you what they said, but what they said out of court in the operation room would be hearsay. So what this person said in the operation room, the drill bit looks wobbly, that would be hearsay. And now if they come on the stand and says, out there in the operation room I said those words, well, it's still hearsay. Even though she's on the stand and can be cross-examined, that's not the definition of hearsay. The definition of hearsay is any out-of-court statement offered in court for its truth. And the out-of-court statement, the drill bit looks wobbly. Now, if we offer this for its truth, that the drill bit really did look wobbly to her, then if you offer it for its truth, then it is hearsay. But if the nurse number one who said this was on the stand, and while on the stand said, when I was in the operating room, I said that, it's hearsay because she's offering an out-of-court statement for the truth of what it says. Doesn't matter that she's on the stand and can be cross-examined. The ability to be cross-examined is part of the policy behind the rule. But the rule is not about cross-examining. The rule is, are you saying something, are you repeating something now that was out of court and offering it for its truth? That's what the hearsay is about. So, but she would say, yes, nurse number one would say, yes, that's what happened, but nurse number one has an exception to the hearsay rule. He or she is on the stand and says, when I was in the operating room, I said, the drill bit looks wobbly to me, and if I'm offering that now for its truth, the hearsay exception I have is declaration of present state of mind. Because at the time, the nurse was observing the drill and saying something that describes it. So 803, declaration of present state of mind, is 803, 1 or 2, I forgot which one it is. And I think it's 803, 1 or 2. 2, I guess. I don't know, it doesn't matter. So declaration of present state of mind, declaration of present state of mind is, I'm saying the wrong thing here. So sorry, I'm trying to get the numbers right and saying the wrong words. When you're out of court, just to be sure I get this clear now, and you see a car going down the street, and you say, that driver must be drunk. That comes under the present sense impression exception. Whereas, if I say to you, I intend to go and kill Joe, that's a declaration of my present state of mind. I like Mary, that's a declaration of my present state of mind. That person walks like he's drunk, that's a present sense impression. And so the person, nurse one on the stand, would use the present sense impression exception to the hearsay rule. Present sense impression, not what I was saying a minute ago. Sorry about that. So if nurse one were taking the stand, she'd use the present sense impression, or he'd use the present sense impression. But that's not what happened. What happened is that nurse number one said it in the operating room, and let's suppose for the moment that nurse number two is the person who makes the surgical report. So when the surgery is all over, nurse number two writes down, nurse number one said the drill bit looks wobbly. Well, now you have two exceptions to the hearsay rule. First, you have the person declaring their present sense impression, that's your 803-2, or 1, whichever it is, declaring their present sense impression, and the person who wrote it down after the surgery is over has a business records exception. So you have two exceptions: declaration of present state of mind, how the drill bit looks. I'm sorry, I keep going back to that. It's a present sense impression. My senses, my eyes see the drill bit looks wobbly. So present sense impression, and then the person who wrote it down has the business records exception. Now, in this problem, it's very similar to that, but things are a little bit different because here, nurse number one in my hypo is the nurse they're talking about here, and here it's the same nurse who said it who also later wrote the surgical report. And so when the person is writing the surgical report, doesn't matter which nurse wrote it, it's still going to be a business record. But when the person who said it declares, says, my present sense impression, I see the drill bit wobbly, and then later I'm going to tell you about it or testify to it or write it down, I still need to use that first level of hearsay. So the first level of hearsay from the nurse who saw it says, that drill bit looks wobbly. Okay, you've got a present sense impression, somebody writes it down, business records. And that's how this would go. So that if it's coming in for its truth, that's how you'd have to have double hearsay. If it's coming in for the fact that it was said to give the doctor notice, then again it would come in. I mean, just the fact that the person who wrote it down says, I heard somebody say that. That's part of a business record, but you don't need the double hearsay. You're not offering it when the person says the drill bit looks wobbly. You're no longer offering it for the fact that the drill bit really is wobbly, but just the fact that the doctor heard it. And if you're just offering it for the fact that the doctor heard it, and therefore maybe was grossly negligent, you still need the hearsay exception of the business records because it was written down in the business records. But you don't need two levels of hearsay because you don't need the present sense impression because what I said, this drill bit looks wobbly, is not being offered for its truth, it's just being offered for the fact that I said it. That brings us to next, line 35. Doctor says, yes, that's her opinion. Question, okay, speaking of opinions, are you familiar with the book General Surgical Techniques by Tompkins, aren't you? Doctor says, yes, I am. And it's authoritative, isn't it? Doctor says, well, some people think so. Well, if we're going to read from this authoritative book, we've got to establish the fact that it's authoritative. Let's take a look at that hearsay exception so you can see what it is that we're looking for. In this hearsay exception, take a look at 803.18, I believe it is. Yes, 803.18. 803.18 is the exception for the learned treatise. And if this book that we're trying to get the in, or part of it in, this is by General Surgical Techniques by Tompkins, that book is probably a learned treatise. And how do you decide if something is a learned treatise, and what can you do about it if you do have a learned treatise? And that's what 803.18 is about. And what it says is, learned treatise, to the extent called to the attention of an expert witness upon cross-examination, or relied upon by the expert witness in direct examination. Well, Dr. Jones didn't rely on it, but Dr. Jones is a hostile witness, and so we can treat him like we're cross-examining. So it's called to this person's attention on cross-examination, so to speak, hostile witness. So it's to the extent that the attention of an expert witness upon cross-examination is called to their attention. Well, is Dr. Jones an expert witness? Well, Dr. Jones is certainly an expert, but nothing about what we have done in this trial so far he hasn't been voir dire or literally qualified in the court as an expert. Until he gets qualified by the court as an expert, he's not an expert for these purposes. And so, should you treat Dr. Jones as an expert witness, well, they are treating him like one, but you might point out that he hasn't really been qualified as an expert. But that wouldn't do you much good, because if you're Dr. Jones's lawyer and you say, gee, these people haven't qualified Dr. Jones as an expert, well, they just do it immediately, so it wouldn't get you anyplace. Continuing. Statements contained in published treatises, here's one of them right here, periodicals or pamphlets, or a subject of history, medicine, or other science or art, established as a reliable authority. So this book on surgical techniques needs to be established as a reliable authority. And Dr. Jones was asked, do you think it's authoritative? Dr. Jones says, some people do. Well, you got a problem there. Are these some people who know enough to determine that this book is authoritative? Are we talking about some people in the streets? So you would point out that it isn't clear. One of the issues you'd raised, it isn't clear that the book has been established as authoritative. But continuing, it says, to the extent established as a reliable authority by the testimony or admission of the witness, or by other x-ray testimony, or by judicial notice. So one of our problems here is we haven't established it, but you talk about some of that. And you say, if admitted, the statement may be read into evidence, but may not be received by the jury. So if we let this in, we're just going to let the person read it, but not admit it. So continuing then at item 9, says, and this book says, page 255, always test drill bits before using them in spinal surgery, doesn't it? And so that's at item 6, that's when you bring up all these issues we talked about. You're not sure that the book has been established as authoritative, because Dr. Jones didn't clearly say that Dr. Jones treated it as authoritative. Dr. Jones didn't name anybody else who did, just said some people do. We don't know who those people are. So we're not sure it's been ever established as authoritative. No one asked for judicial notice to declare it as authoritative. So we're not sure it's authoritative. Next is Dr. Jones, an expert. Sure, Dr. Jones is, but she hasn't been qualified here. No one did that. And then finally, if you get it in, it can be read to the jury, and that's exactly what happened here, was read to them. Continuing, Dr. Jones says, the question was, and on page 255 it says, always test the drill bits before using them in spinal surgery, doesn't it? And Dr. Jones says, I guess so, but again, that's his opinion. Question, now, you've had some troubles yourself in the past. Answer, what do you mean? Question, well, you were accused by 2 patients of having sexually abused them, weren't you? Okay, well, you see the problem. If this person wants to impeach Dr. Jones is testifying and therefore can be impeached. If you want to impeach Dr. Jones, you have to use the normal methods of impeachment. Okay? You can impeach Dr. Jones by bringing on refutation evidence that Dr. Jones is not honest, refutation or opinion, or you can bring in, certain specific acts, crimes, convicted crimes. So, but you cannot impeach Dr. Jones by talking about his sex life, and that seems to be what's going on here. And so this is your objection to at item 7, where you were accused of sexually having abused them, weren't you? The objection would be that, first of all, it is substantially more prejudicial than probative. Secondly, if it's offered for impeachment, this is not a proper method of impeachment. It's not proper because here's what you can do, and this isn't any of those things. So it's not proper impeachment, and it's not relevant. It's not logically relevant. It's not legally relevant because it's too prejudicial, and it is not a proper method of impeachment. Dr. Jones answered that was all nonsense. And question, but do you admit that in 2 other operations which you performed in 1995, the drill bit which you used slipped doing back surgery, causing injury to your patients? And your objections are, of course, that is character evidence. Prior conduct, prior negligence cannot be used to show negligence on this occasion, and that's character evidence, not admissible to show conduct on this occasion. That's a 404A. Pardon me, that's not 404A, it's a criminal conduct. But just in general, prior conduct is not admissible to show conduct on this occasion. And so it's not admissible. That is the end of this question. Those are the objections you should have made. Let's take a look at the next one. February 98. So about page 12. I'll give you 3 minutes to review that quickly, please. Okay, just before we start with this question, let me point something out to you regarding these type of questions. In these transcript questions, in the transcript questions, do not do what we have over here: relevance, foundation, exclusions. You recall that if I have an item of evidence, a bald tire, a piece of testimony, a document, and I want to know whether or not this is admissible, this is what I go through each time for each item of evidence to see whether or not that item is admissible. But when we are doing over here these transcript type questions, we now are simulating a trial, and someone is at trial, and you are to object to some question or answer at the trial. In those cases, what you should do is not go through relevance, foundation, exclusion. Instead, what you do is you identify the objection, okay, name it, there's the objection. Then secondly, you give the rule. Third, application. And a conclusion, which is the ruling. This is the ruling. They ask you for the ruling. So this is how you do these. We have another one coming up right now, and let's stick to this file now so we can see how it comes out when you do it that way. February 98 question. Says, Don is being prosecuted criminally for committing an armed assault against Victor. The evidentiary issues presented in his jury trial are based upon the following chronology of events. Number one, June 5th, and they asked us to comment on the evidence offered at items 13, 14, 15, and 17. (13, 14, 15, 17). They asked us to comment there and answer the question that they asked, but this is the style which you use to do that. So let's move ahead. We don't have to do much until we get down to item 13, except we do have to understand what is going on. Item 1. June the 5th, 1985, Don was convicted of bribery. Now, immediately, when you know someone's convicted of bribery, if that person testifies, you have an excellent opportunity to impeach them, so expect to use that prior bribery conviction. But you and I know that prior convictions can be used to impeach if they are within the last 10 years. And particularly a conviction that has something to do with dishonesty, like bribery, as opposed to fighting. So this prior convicted bribery, you know someone's going to try to use it to impeach Don, that Don's probably going to testify, and someone's going to use this to try to impeach him. Now, this conviction must be within the last 10 years, and and so let's keep that in mind. So he got a 3-year sentence, which he served in full without parole. So let's see, in 1985 he was convicted, so he got out in 1988. And this was a 1998 question. So we're right at the 10-year edge, from 1988 to 1998. We need to know more exactly how to count the 10 years when it's that close. So take a look at how the 10 years is counted. Take a look at your evidence codes. This would be at section 609, 609B. So 609B, I'll read it to you, says time limit. Evidence of a conviction under this rule is not admissible if a period of time more than 10 years has elapsed since the date of conviction or the date of release from confinement, whichever is later. And so here he was released. He went to jail in June of 85, so he got out in June of 88. And when is this trial taking place? Well, this is a question that's on the February 1998 bar exam. And so this person was released in June of 1988. They were released June 5th, 1988. So if he was released June 5th, 1988, his 10 years are up June 5th, 1998. But this is the February '98 bar. So this person has not been out of jail for 10 years yet. Let's keep going. June, this is item 2, line 13. June the 1st, 1997, Victor was assaulted allegedly by Don. June the 4th, 1997, Victor identified Don from a lineup as the person who assaulted him. Item 4, June the 6th, 1997, Don confessed privately to his longtime fiancée Bernice that he, Don, was the one who assaulted Victor. Now, we've got a problem here because he confessed to his fiancée, but there's no special privilege that applies. And so, in principle, if the DA found out about this, the DA could subpoena his fiancée and say, come and testify as to the admission that Don made. Admission, don't forget, Don's out-of-court statement is hearsay, but you've got the admissions exception to the hearsay rule. So the prosecution could call Don's, could call Don's fiancée. But suppose they get married. Okay, now if they get married, we've got a different issue. Because a common law, spouses could not testify against each other. They were not even competent to testify against each other at common law. So at common law, now that they're married, she could not testify against him. But we don't treat it as a matter of competence nowadays. We treat it more as a matter of privilege. And we say, as a matter of public policy, we do not want to require a spouse to testify against his or her partner. Bad public policy. And so what we do then is we say the person is privileged. And if you try to get a spouse to testify, the person can assert their privilege. But now the question becomes, who does the privilege belong to? Does the privilege belong to the spouse that you're asking to testify? Or does it belong to the defendant? We're talking criminal cases now. And so if it belongs to the defendant can say, my spouse can't testify. If it belongs to the testifying spouse, the person can say, I don't want to testify. But the person might also say, I hate the scum, I want to testify. So if the privilege belongs to the testifying spouse, they can waive it if they want to. Some jurisdictions, the privilege belongs to the defendant's spouse in this criminal matter. Some jurisdictions, it belongs to the testifying spouse, and some jurisdictions it belongs to both. So here we're now at the point where Don has told his longtime fiancée, he's made a confession. She could be called to testify. They're not married, but the next thing that happens, of course, is that at item 6, on August the 15th, 1997, Detective Phillips, who had been at the lineup, testified at a preliminary hearing. Now that's going to get us into some additional discussion, so let's come back and pick up item 6 right after the break.